Welcome to the Jury Thinks What podcast. Part of the Lawyer Minds ecosystem, the Jury Thinks What podcast discusses everything there is to know about trying cases, from preparing the case before the lawsuit is filed, all the way to trial. And most importantly, how to understand what the jury is thinking. During our journey, we'll be talking to some of the brightest trial lawyers from many walks of life. What makes them successful? What makes them different? Do they have secrets to dealing with the jury? Let's find out. Here's your host of the Jury Thinks What podcast, Saul Gruber.
Welcome to the Jury Thinks What, where we have a podcast for trial lawyers by trial lawyers, and our goal here is to give everybody some insight on what fairly successful trial lawyers are doing and how we can use their knowledge to help our clients. My name is Saul Gruber. I'm with Gruber Trial Consulting, and I'm pretty thrilled about our guest today. He's Michael Neff out of Georgia. Good morning, Mike. How are you doing today?
Hey, Saul, how are you?
Excellent. Michael is a pretty powerful lawyer out of Georgia with multiple verdicts in the top 100 every year, whether it be against a grocery store with a fall case setting record-setting verdicts in the state of Georgia. But just as important, Mike has shared his knowledge with all of us through trial guides on his new book. If I get this right, Mike, Premises Liability, A Guide to Success. Is that right?
That is book one. We just got book two in, which is going to be a guide through trial. So that's next year. Yeah.
Oh, we're going to have to bring you back on to go over some of that, because that's exactly what we want you to do to help all of our listeners, is a guide through trial. What made you, and these books we can get on trial guides, right?
Yes, book one is available, and book two should be out next year, second quarter.
Great. What got you into writing books?
Well, it was an amazing story where I was having lunch with a young lawyer, and it was the day of snowpocalypse, which in Atlanta was about 3 years ago, where it took some people 8 hours to go 2 miles home, because we do not deal with ice and snow well in the deep South. So I was sitting at a lunch that I thought would be in and out, and I was talking to this younger lawyer about the Six Flags trial, which wound up being a $35 million verdict back in 2013. And the lawyer sat with me and said, "When you were in law school, did you ever see yourself trying a $35 million case?" And it was kind of like in the movies where you go back in time and it gets wavy. And I kind of checked out for a half a second and came back and said, no, I didn't know what a $35 million verdict would look like or feel like in law school.
Did you ever even think you'd be trying cases when you were in law school?
You know, actually, when I went to law school, it was with designs to be a real estate developer. And but I got bit by the tort bug in the first week or two. In fact, the tort professor would start calling on me in week 3. Let's hear from the plaintiff, Mr. Neff. What say you on the plaintiff? And it was kind of amazing. He recognized, I think, before I did, that, you know, my mindset was kind of coming down in class, always for the little guy. And it just kind of built like a big snowball. And I got back from an hour drive for me to go a mile, which I was a lucky one. And that question stuck with me. Like, could you see this coming? And, you know, I have a lot of lunches and a lot of breakfast with people before COVID. And no, I didn't. But now that I look back at things, I see mile markers where I learned a lot of things from guys like David Ball and, you know, Rick Friedman and some of those guys, Pat Malone, the trial guides authors. I've read a number of books, and, you know, I thought, geez, maybe I have something I could share. And I sent them a proposal and they said yes. And it was kind of
great.
Yeah.
What was it like writing the book, though? How was it writing a book?
I joke that it's the closest thing a man can come to having a child and giving birth. Although the gestation period was longer than 9 months. Yeah, it was tough. And book 2 was a little bit easier, but still tough. And, you think a certain way and you have to kind of filter it onto words. And, as lawyers, our job is to convey messages for audiences and frequently speaking, sometimes in briefs. But, it has really been interesting to kind of look back and say, what do I feel very confident works from my journey, from my experience? And what do I think is universal?
And we're going to talk about, that's pretty important stuff. And what we're going to get to in a few minutes is voir dire. And we know how important voir dire is because it really, it's what puts jurors on our jury. And if we get the wrong jurors, it almost doesn't matter what we do. And we definitely want to pick your brain on that. I know everybody's waiting to hear. But so the book part is fascinating to me. But how did you start having this subspecialty of premises liability as opposed to other different types of law?
Well, it's funny because I was told as a young lawyer, sometimes you pick the law and sometimes the law picks you. And I wanted to be a trial lawyer. And so I eventually, when I started my practice in 1996, got to all personal injury. And one of the kind of serendipitous things in life, I married a lady who is a civil engineer with a specialty in construction management. And I always had a real estate interest, starting as I was a real estate agent at 18. And so I loved property and property rights and representing injured people. And, I got a couple of cases and I started asking my wife about them because she's a Navy officer and, safety was really trained into them. And she started telling me all of these policies and procedures and rules and safety best practices. And I was like, wow, this makes a lot of sense. It was rules of the road before it was written.
Sure.
But according to Lieutenant Commander Neff, and it was really amazing. She was my secret weapon for probably the first, 10 cases, premises cases I had. And, then I started working with a trial consultant and, it was just kind of building things up. And then we had kids and Mrs. Neff retired from being my consultant and said, go ask your trial consultant how to frame these things. So, but, it all starts with, how do you win this case? What do you have to convey to a jury? And, premises liability cases are like the redheaded stepchild because, people think of banana peels and slip and falls.
Yep.
And scam artists. And, you have these negative, pejorative stereotypes you have to overcome to bring a legitimate case in the eyes of the jury.
So you're really behind the 8 ball when you start a trial in a premises case.
Yes. And, it's interesting because, forever and a day, medical malpractice has kind of been like, oh, those are the hard cases. Those are, really tricky psychologically and factually. And they are, and the defendant is frequently sympathetic, particularly depending on your venue. Premises cases can be really hard psychologically. I've sat through a lot of focus groups, which is going to segue us into voir dire. And you hear people say things like, well, how are we supposed to hold a property owner responsible for the intentional act of a criminal? What are they supposed to do to prevent that? And why is this fair? And, you hear questions like that. And those are the questions where you're like, oh, I can't win this case with this juror. I better find them or I'm in big trouble. And that's kind of how it gets going.
So it really gets going the same way all of our cases get going. I've handled nursing home cases for 30 years. And I always joke that we were in the catbird seat compared to the rest of you because not a lot of people really like nursing homes. And trying to show that they're not a great place to be was what the defendants were trying to get over that as the real problem in the case. But it all came down to how we framed the case and how we framed the case to the jury. And that's all that really matters because there's so many different ways to say the same fact. you really have to do some research and figure out how it's going to resonate, I guess, with the potential jurors.
Yes. I mean, I loved, Polarizing the Case by Friedman and Malone, because it made you think, how do I take the defense position and beat them with it?
Right.
How can I reframe this so that a negative is a negative for them? And, how can I build my credibility? How can I attack their credibility? Those are kind of the universal themes of trial. If you can win the credibility battle, if the jury trusts you and your client, you're going to be successful more often than not.
I heard from somebody, and I really wish I could remember who it was, who was lecturing at one of the things you and I are always at, whether it be Georgia Trial Lawyers, New Jersey Association for Justice, or AAJ. And she was a female. She was saying that, remember, the opening statement is so important because it's the first time you are going to make an impression on these people. Now, I didn't raise my hand, and I would never, but my theory was, no, it's not. It's the second time. The first time is not here. And
Absolutely.
if you screw that up, as we'll talk about, you're not going to get a second chance in an opening.
It's going to be an uphill battle to get that trust back. So I agree with you. Voir dire is the first date, and it's like speed dating because you don't get a lot of time, and you have to make an impression so that you hopefully can get to a second date. And then, closing argument, you're asking them to marry your case. Right. So, I mean, it really is a really interesting psychological dance that I frequently compare to dating.
So let's talk about the first date. And I call it voir dire, you call it voir dire. That's the difference between New Jersey and Georgia, I think. But now that I'm in Miami, I still call it voir dire. In Georgia, which is primarily where you practice, what type of voir dire do you have?
Fortunately, in state court, it is for the most part attorney-driven voir dire. And of course, the hardest thing is that everything is judge specific. So, you have some judges that'll give you an hour, some that'll give you 3, some that'll give you a day, depending on how big the case is. And then, of course, when you get in a federal court, it's frequently predominantly judge driven. Right. And, it also varies depending on the judges. Some judges will give you a little latitude. Some judges will give you a lot of latitude, and it's not so prejudicial. But that is also the dance that we have to do, is try and figure out what music the judge is going to let you play.
So that's really the key to do. The first is you have to find out, what your judge is even going to allow you to do. Because the worst thing you could do is get ready for a 2-hour voir dire, and the judge says you have 10 minutes. And you look down at your notes and you look back up, and what do you say? Jury satisfactory?
Can I please more? Yeah, no, it's tough. Yes, that is the best advice, I think, for younger lawyers is, you really need to do your scouting report, get on your listserv, call your more experienced buddies and say, who's ever tried a case before this judge, and tell me about how they do voir dire. And, you got to start with that. You just have to know what you can get away with, and also talk at the pretrial conference and get it from the judge.
Do you, before you start any voir dire, and then we're going to get into some issues there, do you speak to the clerk to find out any quirks the judge has, what the judge likes you to say?
Will. Yes. I mean, in addition to doing that scattering report, the staff attorney, we'll chat with them at the pretrial conference. And, frequently the judge will kind of give you the lay of the land. They'll bring in, 36 or 48 or 60, depending on how big a case it is. And they'll lay them out, 1 through whatever. And you can be prepared to have your boxes, to write their names and do your notes and have your grid, if that's, how you handle it.
How do you handle it? I mean, we used to seat, because in New Jersey, we would normally have 6 jurors and 1 or 2 alternates. We would seat 8 out of a panel of 40, and then I'd have my legal pad, into 8 little boxes where I can write names in. How do you do it?
Well, I have help because I can't do it all. We are doing juries of 12 in state court. in federal court, I've seen 8 or 9, depending on the judge. And my job, as I see it in Voir, is to be the host of a cocktail party with no drinks and get to know these people. And to me, that's a full-time job. For especially for a big case, I have to listen, and I have to try and think of a follow-up question. Hopefully the judge permits that. And generally in state court, they do an immediate follow-up, or at least a general question. Like I might ask something along the lines of, does anyone here have any problems with us asking for a significant amount of money, maybe millions of dollars? And people will raise hands, and you might say, tell me more, like Eric Oliver, who's a trial consultant. He likes to espouse, tell me more. Who else feels that way? I think David Ball says, and I've ripped off everybody, so I don't even know, where I kind of evolve from. But yes, I try and get that conversation going. And I've found the best way of doing it is if I can say, does anyone else feel that way? Who else here feels that way is better? And people start raising hands. Yes, number 35, Mr. Jones. Tell me a little bit more about that. And then he'll talk. And when they get into a conversation as a group, now they're kind of just unilaterally volunteering information. And you are getting people's body language, and you're getting their tone of voice, and you're getting the content of what they're saying. And it's good, as opposed to a kind of antiseptic, who and hands, and you're not really getting a lot of information to read people.
So you have somebody sitting at counsel table that's taking notes and sorting it so that you can look at it and make some information out of everything you're hearing.
Multiple people, typically, yes.
Are you you're not permitted to tape that or record it, are you?
No, we've never recorded it because you really don't have time. I mean, we got to pick it.
Right.
We go through the questions and we're picking them the same day. So you don't really have time to go back and real time stuff. So that's why it helps to have multiple friends.
Now, while you're asking these questions and they're answering them, you said something that was interesting. You said tone and body language is important. Can you tell me more about that? That's my expert question. Can you tell us more about that?
Yes. Well, I've been married for 17 years, and you learn over time how to read people. And if we went back to before we got married, you had to learn how to read people. And it's not 100%, but I think as trial lawyer, you need to be kind of in touch with people, and you need to sometimes trust your gut. What do I think about this person? Do I feel good about them, or do I not feel good about them? And when they were talking about this subject, was it 1 out of 10 bad, or was it 10 out of 10 bad? Was it 5 out of 10 bad?
Because you have the key here. Yeah, and the key here is engaging them in a conversation, I would think, as opposed to asking them any kind of question where it's a yes or no answer.
Yeah, open-ended questions. If you can get them talking, to me, it's worth triple or quadruple points compared to, who here, feels this way about this subject, and you get a hand. Well, you can't read much into a hand. You could just say, here's one data point. But if you get someone talking, there's frequently 4 or 5 data points. They'll confirm something, they'll volunteer something, you'll see their tone of voice, which can tell you whether you think they're going to be a leader or an influencer. And those are really hugely important bits of information. You're trying to eat soup with chopsticks, so you're just doing the best you can.
Is it important to you that you think they're a leader or an influencer?
It is important because that person could be your foreperson, and because their beliefs, if they're a leader, can make or break you. So I think the safer thing that I've heard from some trial consultants is strike a leader, but I think that's just kind of one of those sayings like, well, no, you strike leaders that are going to lead against you. You keep leaders that are on your side, but
you have to be pretty sure they're on your side to want to keep that leader, though.
Yes. Yeah. I mean, I remember as a young guy, one of my first 10 trials or so, a retired military officer came up to me after we picked the jury, and he wasn't on it. And he said, "This is the fifth time I've shown up and I really want to serve and I'm not getting selected." And I said something along the lines of, "Yeah, I think it might be because, you were an officer and you have a strong persona that, one side or the other is worried that you're not going to go their way."
Right.
So it is important. And it's, another one of those gut intangible decisions where we're just trying to get as much information and say, "Hey, how do you feel?"
And I think a lot of what I see as a consultant, that's why I laughed when you talked about the leader. I was like, well, I don't know if I would not strike them or not. It really depended on what I thought, who they were going to believe. But we really don't have to convince 12 jurors about something. We've got to convince just a few jurors who then convince the other people. And if we pick those leaders correctly, we have someone arguing our point back in the jury room. And that's something a lot of lawyers, I think, forget.
Well, it's really interesting because in Georgia, it has to be 12-0. It has to be unanimous verdict. But in reality, if it's 11-1, usually the one doesn't hold out, usually. Now, they might mess with your damages, but usually they won't be able to hold out. And really, when you're in trouble is when it's 8-4.
Right.
And then you've got 4 people that are getting support, and then you're really going to get your numbers hit.
Well,
just
then you
to
get
win the case, maybe.
Yeah, serious compromise verdict or a loss at that point. So let's take a step back. You've got a trial date. Let's say it's 30 days from now. Are you able to get the names of the jurors at any point in time before?
No, not certainly not in Metro Atlanta. I've heard in rural jurisdictions that you might get, and you might be able to get that somewhere, but I've never gotten that in advance in any venue that I've tried a case in Georgia. So you get it that day, and they give you very thumbnail sketch. Your name, are you married, where you live, how old you are, do you have kids?
That's already more than we used to get in New Jersey. We used to get their name, what town they lived in, kind of what they did, and that's it.
Yeah, and you get their spouse's occupation too, which is sometimes you'll see something like insurance adjuster, and you're like, oh, all right, well, I know what I'm going to ask them.
Now, if you see insurance adjuster, do you automatically, as a plaintiff lawyer, think to yourself, I'm just going to try to strike them no matter what, even if I have to use one of my preemptories?
90 some high number, yes, but I actually have had an insurance adjuster on a jury before and lived to talk about it. Wow. So I mean, I think the thing that's really interesting about Voir is it's hard to have universal rules. You can have universal guidelines, but I mean, we had a med mal case where we kept a nurse on the jury that reviewed med mal cases for defense firms and won a 7-figure verdict. And it was just, you roll the dice sometimes.
I found every time we have left a nurse or an aide on a jury in a nursing home case, it has come back to burn us. And
it's amazing. Well, I mean, I may be lucky. So, better lucky than good.
And I was always shocked because we left them on in cases that we really thought were pretty slam dunk cases where the nurse would be pissed that another nurse didn't do something, and it always has come back to haunt me.
Well, it's an interesting point because I call that maybe there, but for the grace of God, go I.
Yeah.
In premises cases, one of the things that shocked me as a young guy that I was able to learn through focus groups is if somebody owns a rental property, they're not going to go your way on a premises case because they're going to be terrified about this happening to them. Even if they violated rules, even if it's crystal dang clear, it hits too close to home.
So that's interesting. So are you focus grouping all of your cases in some way, shape, or form? Before trial, I mean.
Yeah, for I have 3 other lawyers in my practice, and for the cases that I'm working on, we will do focus groups. And then there are some cases that I kind of consult on in-house, and you think about, do you do it on this case, and how much do you spend? Focus groups are fascinating. To do them really well can cost a lot of money.
That I'm aware of.
To do them pretty well, you might shave a couple corners. And, it's an interesting process. And the nice thing about them is the more you do, the more you kind of develop an appreciation for how you're going to build a case.
Right.
And, but I think, you should definitely be focus grouping cases a lot.
I've told people that one of the suggestions I've had for every litigation firm is they have focus group Friday, maybe the last Friday of every month. Mm-hmm. Go to an employment agency, do your ads in the paper. You don't need anybody professional. Have people come in even to your office where they sit in a conference room, you get a pizza, you turn your video camera on, and you talk to them about issues and just find out what they're thinking. Not a day goes by where we don't have an issue as a trial lawyer, whether we're going to trial next week or not, that we don't want to know information on.
Well, I think it's interesting because I did early in my career, I did a lot of the employment agency focus groups because you could get people in and you could do it for, under $2,000 and, all of this information. And it's really good information on liability issues typically, but, in the perfect world where you have a case that warrants it, you're going to want to get more diversity.
Right. And at least something that reflects the jury pool of the county you're in. And that's why I say I call them separate focus groups. They're the ones where they're in the big cases where you're definitely going to sink the money. But if you just want to know what the thought of a normal person, because let's face it, we're not normal.
Oh, I agree. No, I agree. That's good.
It's an easy way. So you do your focus groups.
Mm-hmm.
What do you do a focus group? Or I should say, how do you use the focus group to prepare yourself and do voir dire?
Well, I'll give you an example that comes to mind. We tried a case back in 2013. It's a Six Flags case. And what happened was our client got attacked and beaten into a coma by some gang members. And the case was being defended on the basis that the attack happened at the bus stop that was outside of the park, and it wasn't on park property. And so the first time that we did a focus group, people had a lot of difficulty with the concept of what's an approach and how a property owner could be responsible for an attack that didn't happen technically on their property. So we started talking, we started realizing, okay, this is something that we're going to have to figure out, is how people feel about this concept. So we would in voir dire, we asked questions about property lines, and we asked questions about taking control of property that you don't own, because under the law, it's, where the property is, or if you've taken control of property, or the approach. And so we learned to ask questions about how people feel about this concept of property lines and control. So you just hear, when the jury in the focus group is deliberating, listen to, the points that the defense jurors are arguing. And they usually go back and repeat the same thing a couple of times. Well, that's where the defense folks are hanging their hats on these themes or these points or these facts. And then you're like, okay, I need to introduce that in voir dire and see, is there someone hung up on this point, that I can't move, that they're going to have an intractable position on. So that's where I get a lot of ideas for, I better find out if someone has an intractable position on this issue.
So you're focus grouping, and if we see an issue that's coming up, a lot of the same issue coming up with different jurors, wait a minute, we need to find out how can we get around that issue. Maybe the focus group gives you something that you can then use in voir dire. Is that kind of what you're saying?
Yes, although I'll say, typically on a big case, you do a focus group and you learn a lot, and then you redo your focus group and you do it a second time, and then you learn still a lot, and then you redo it a third time, and then you're probably realizing, hey, I've tweaked this, and this is the traction I get, or these are the resistance points,
Right.
or, these are issues that I can't or I can work on. And that is the homework that we have to do to really get to know our case and to really think about what type of jurors do I need to get off this panel so that I have a chance for my client.
So for the lawyers out there listening, it's not a matter of getting up and smiling and getting the juror to talk. You really need to know before you go in there what you want them to talk about, and based on what their answers are, whether they're going to be good for your case.
It's a combination of a lot, but I agree, you can't just be charming and good looking. You kind of have to have a plan. You do want to be a decent person. You do want to be respectful of their time, but you also need to be armed with, hey, I need to find this out. This is the goal of Voir. This is what I need to do in order to do my job.
So even if you don't do the focus groups, at least you want the trial lawyer to sit down and say, all right, what are the things that could really hurt me? What are the things that can really help me, and kind of build from there for his voir dire? Does that make sense?
Yeah, one of the best nuggets of advice I had in getting ready for trial was to take out a piece of paper and write down the 10 things that scare you the most about this trial,
right,
for the defense perspective. And, once you write those 10 things out, then think about how you might be able to combat them or beat them. But those 10 fears are also things that can guide your voir dire, because you're going to want to know about what this juror's potential feelings are on themes or on, you don't prejudge cases, but you get into certain issues or facts to see if their mind is going to be open for you.
Absolutely. In fact, we tell all our clients to do that. We say top 5. The top 5 things you think are great in your case, and the top 5 things that you think are great in the defense case, and start working out from there. And one of the other things I tell my clients always is, whenever you have an expert deposition, I don't really care so much what the expert says, because at the end of the day, we'll read that later. I want to know what questions are being asked by the different lawyers.
Yeah.
So I think if I have a key expert, I want to know exactly what the defense is asking him or her in his or her deposition, because a lot of times they're signaling to us, this is my theory. This is
absolutely
what I need. And then turn that around.
Yeah. And one of the things that I loved about my journey through AAJ and trial guides and learning how to be a trial lawyer was, eventually the light bulb went on that I controlled the questions. And if I ask the right question, I can't lose, because they either agree and I look good, or they disagree and they look bad. And you're right that the questions are instructive and illustrative of a lot of things. So absolutely.
The other thing I like to do, if I've never tried a case against that defense lawyer yet, do my best to find out, to try to grab an opening that they may have. I mean, if they're a defense lawyer that's trying a lot of cases, some of them went up. I'm sure some of the openings have been transcribed.
Right.
Take a look at it, because that may really help you in voir dire as well in asking some questions.
Yes. I mean, if you know your case well and you know what the defense is going to argue, then you're going to want to identify the potential jurors where these issues will resonate, because you have to intelligently exercise your preemptory challenges. And in order for you to do that, you need to ask some degree of questions about what people's feelings are and which way they lean.
Right. So do you do the which way they lean questions?
I do, because in Georgia in particular,
if you could just tell our listeners what they are, like what a which way do you lean question is, and then go from there.
Right. So, for example, we have preponderance, and preponderance, 50.1% or a feather weight. And I'll say something like, some people think that because the law, and this is straight from David Ball, but some people think that just because the law requires 50.1%, that's okay in a small case. But other people think in bigger cases, when there's more money at stake, that's not enough. So which way do you lean? Do you lean towards 50.1 is okay, no matter how big the damages are? Or do you lean towards, if it's a big money case, I'm going to need more than 50.1%? And that'll identify potentially people you can get struck for cause, depending on how fixed their opinion is on I want more. Now, I've consistently gotten people off because they say, no, if it's a big case, you're asking for millions and millions of dollars. I need to be convinced.
Sure. Now, what do you do when they say that and you ask the judge to strike them for cause, and the judge says to them, well, if I instruct you what the law is, can you be fair and impartial and follow what I instruct? And they say yes.
Well, I've learned to ask more than one way to try and build that record, because you're right. If you only ask which way do you lean and you get a hand, Mr. Jones, number 35, and the judge leans on them, and they're not supposed to, and in Georgia we have good appellate law on that, but sometimes they still do. But if you follow up with that witness, juror number 35, and you say, well, how long have you felt this way? Or how strongly do you feel that the way? Is this something that you feel, just blasé about, or, hey, millions of dollars, there's a lot on the line. You really feel strongly about it. If they say, I really feel strongly about it, and you have that, and you might ask, well, a couple other questions depending on what they say. So you're building a little appellate record on it. The judge is more likely to go your way, depending on the language they use. And that's the thing that's tricky about it is, there are few magic word appellate cases in Georgia that say, hey, if you get this, you're 100% clear. It's kind of like the pornography, you know it when you see it,
right?
But you're building a case to get this person struck for cause.
So we're with Michael Neff from Neff Injury Law, and the new author of Premises Liability, A Guide to Success. Well, not a new author, that's his first book, but his second book is about to come out next year. And we're talking to Michael about voir dire. So how long in Georgia do you normally have voir dire?
It varies case by case. I've had an 8-figure case that I got 2 or 3 hours. I've had an 8-figure case where I've got 3 or 4 hours. I had a 7-figure case I got more than a day.
More than a day?
Wow.
Yeah. Wow.
Yeah. That was a great judge. And that turned out to be a $2.79 million verdict on a slip and fall in a grocery store. And we got like 11 struck for cause. Do
you think, based on your experience, the more voir dire you get, the better chance you have for a bigger verdict?
Wow. No. I think the more voir dire you get, the more likely you are to get people struck for cause, because you'll have more information. Hopefully, the better voir dire you get, the more likely you are to get a just verdict. But, it feels like you go to Vegas and you're getting dealt cards, and you're just playing the cards the best you can. And sometimes you get great cards and sometimes you get crummy cards. And regardless of what cards you get, you still have to play them.
I always laugh at that one juror who's like juror number 3 in the box, and during your opening, they just nod. And you feel so good when you sit down until you see that same person nodding during the defendant's opening. And then you realize you have no idea what they're thinking or what they're going to do.
I've learned that too. And now I'm watching them nod during voir dire, and then watching them nod during the defendant's voir dire. So I don't go for the head fakes as much anymore.
Now, taking a step back, let's say you have an hour of voir dire. You've done your homework. It's a premises case. What kind of questions are you going to try to get in there in that hour to get as much information as you can?
Yeah, I think an hour is limited. But like, let's say you have a medium-sized case. So I think your idea of cutting it down to the 5 most important things. I think, the universal issue is, how do you feel about damages? And Ball, talks about, how do you feel about damages for pain and suffering? How do you feel about damages for medical bills? And his thought is that if the juror is against damages for medical bills, you're really in trouble. So you got to hit damages and people's feelings on it. I really like the question about preponderance, because that tells me how hard a juror will be to convince. Because if they will accept preponderance,
right,
you better win that case, because, that's not, you better have chosen a case you can win. And if you don't have enough for preponderance, then it was a risky case, or maybe
right.
You chose badly. But you got to get jurors that will give you preponderance. If you can get that, and you can get jurors that are open to damages, you're playing. Those are the 2 issues.
And I've heard the preponderance. Actually, I was just in Ohio doing some focus groups, and I heard the preponderance discussed there by one of the lawyers as taking a sheet of paper from an equal pile, and just putting the piece of paper over there, saying, "Is that enough?" and explaining preponderance that way, which I really liked. And
It's nice.
we had a lot of people say, "Well, not for a big case." In fact, I would say in almost every focus group, almost to a person, when the plaintiffs are looking for big money, it's not enough to show by preponderance of the evidence, according to the focus groups. They want more.
Well, I think that's the reality.
Yeah.
I think people want to feel strongly about it. They want to have a conviction that they're doing the right thing on an important case. So I think in reality, it really isn't preponderance. But you also need to explore that really hard, because if they're going to tell you they're not going to give you preponderance, then that's a way that they should be excused from jury duty.
And plus, you're kind of telling the rest of the panel how important that is.
Yeah, that I think is equally important with, do you have any caps in your mind, or is your mind open to damages? Those are the 2 big ones. And then you get into your case specific ones. Maybe you can do 3 or 4 of your big case themes or issues or facts. That's what I would put in an hour if I had an hour. So
really, there's certain things you're always going to hit: preponderance, damages, because they're the things that are in every one of our cases. And then the top few, as Mark Mandel says, they can't get over issues.
Yes.
Yes. Yeah.
Very good stuff.
Yeah.
Well, if you got a nursing home case, life experience is everything. Has anyone worked at a nursing home? Does anyone have a relative in a nursing home? And then you have to unpack what their experiences are.
What's going to be interesting coming up is how people deal with the comorbidities and pre-existing conditions. My experience has always been, jurors don't think too much about that. Now it's in all of our newspapers and on the news every day, the word comorbidities. I thought it was just us that used that word. I didn't know it was out there. So it's going to be interesting, again, when looking at people and how they look at COVID, may tell us how they're going to think about pre-existing conditions now. And it's something we really have to look at. We started a focus group then, but I'm not a big believer of the Zoom focus group, because I don't think the people that you get on Zoom are the people you're going to get in the jury. It just seems the nature of what I'm seeing is the people that you're going to get in the jury probably for the next year are people who are not afraid of COVID. And that's going to cut out at least 30 to 40% of the jury pool. That we may get those people on Zoom, but we're not going to get them in the jury. So I really want to load it with more conservative people who
younger jurors.
Yeah.
I mean, the 20-year-olds are showing us that they really believe they're bulletproof. And I think 20-year-olds have always thought that, but
yeah, I used to hate putting millennials on my jury.
Yeah.
Because I don't know that there was anything I could say that could ever resonate with them, because as all 20-year-olds, back to when we were 20, we knew everything. We were smarter, and we were going to do it differently. So it's dangerous. I've done some focus groups just with millennials to get a better understanding. And we did one down here in Fort Lauderdale, and their view on damages was frightening. It absolutely frightening in cases where we did other focus groups and George were putting $5 million, $7 million on the damages. The millennial, 750,000, 800,000. You just went,
Well, it's hard for them to view 30 years in the future because
right.
they haven't walked in those shoes yet. So yeah, it is interesting. It's a different world, and we all kind of hope for normal or to improve the new normal.
So we have this is Saul Gruber from Gruber Trial Consulting on the Jury Thinks What. We have Michael Neff out of the great state of Georgia, who I have a lot of clients, as you know, in your area. I'm up there an awful lot, even during COVID. So let's do some takeaways. We know that you have to do your homework before you do voir dire. You've got to know what the judge is going to do and get that from the judge or the clerk, right?
Yeah.
We're gonna do our homework, whether we focus group it or just sit down and think about it. And as you said, you need a plan for voir dire. Just don't go in there and smile. And it sounds like you really want to hit the damages and the burden of proof in every case.
Yeah, I think universally that is your foundation. And then when you get into the analysis of what your case is and what the big strengths and the big weaknesses, and I'll spend all of my time that I've been given for the most part on the weaknesses, right? I mean, it's the defense lawyer's job to figure out, the positive things about my case. I don't really want to ask a lot of questions that is going to make the defense lawyer say, oh, I want to get rid of these people because they look good. Make them do their work.
Absolutely.
And prioritize the stuff that you're afraid about.
And that's the same thing with the focus groups. I can't tell you how many people hire us to do focus groups and are upset when we're done because they quote unquote got beat. And I'm like, well, I think that was the plan. I think the plan is that you want to know everything that's bad about your case. And that's why we normally do 2 in a day, where we try to change things around and really get some information and that you can use. You don't need anybody telling you how good your case is. That doesn't help you at trial.
And the thing that still gives me heartburn or agita, as my Italian grandma would say, is losing on the false narrative, losing on evidence that isn't real, but that either a juror seized on because they heard a quote misstatement, or they filled in some blanks in their mind with assumptions.
Right.
And doing focus groups and seeing how jurors seize or don't seize certain issues or certain facts, that should be leading you into your plan on what kind of questions, what kind of issues, what kind of people you're going to look to get out.
This has been really interesting, Mike. Thanks. I definitely want, if it's okay with you, bring you back when the book comes out and kind of go through your ideas of the best way to try a premises case.
Well, what was fun about the second book is that we used a lot of trial transcripts. And I always kind of like reading other lawyers' questions and witness reactions and then follow up to witness reactions, because you can kind of see how their brain is working, how their lawyer vision works. And that's been helpful to me.
I know that's what I loved about Mark Mandel's second framing book, is he used, it wasn't necessarily theory. It was what we just did. Well, you can ask this, see what they say about that. I mean, that really helps. And then putting it into practice. I mean, you're going to mess up the first time you do voir dire. You're going to be scared. You're going to be afraid to ask any questions. Of course. It's just the nature of the beast.
First couple dozen. I mean, it's not an easy, it's a blind date. You don't know any of these people, and you're asking them to trust you.
That's exactly right. Last question about voir dire. In federal court and in New Jersey, we have complete judge-driven voir dire. About 3 to 4 years ago, the Supreme Court of New Jersey said you can have, wait for it, 3 open-ended questions that you could submit to the judge. If you had 3 open-ended questions, and I didn't tell you I was going to ask you this, what do you think you would ask? What three do you think would be the ones you definitely want to hear?
I would ask a question on caps. Who here, before they've heard any evidence, has a number on damages that they would never go over no matter what the evidence is? So that would be one, particularly obviously in a big case. Or a modest case, that might not matter. And then let's see, I think certainly we're going to ask a question about preponderance of the evidence, and who here, would demand that for more significant damages, they would want more significant evidence than,
right.
Beyond this. And then the third one, let's see. So we've covered a cap on damages. We've covered preponderance. I guess it would depend on the kind of case.
You'd leave the third one for the case.
Yeah. If it's a nursing home case, you might, if it's a particular issue, I don't know. I mean, elopement case, we handled one of those, and those are really interesting.
Makes perfect sense. Save your last one. If you have that type of blind, only very limited judge-driven voir dire where you can submit a couple questions, save the last one to be case specific. And case theme specific.
Look for some articles on voir dire and write a bench brief trying to argue for more. There are articles.
I would also say go to your Trial Lawyers Association. I'm sure GTLA, if there were limits in Georgia, would have something for everybody to argue for constitutionality and things of that nature as well, a bench brief.
We actually have a whole book, a trial manual that has a chapter on voir dire. So it's a very good place to start. Right. But I think part of what we want to do is argue for expansive attorney-driven voir dire. And there are psychological studies out there that have been out there for 2 or 3 decades that talk about jurors are intimidated by judges. They don't answer questions the same way. Particularly in federal court is a very, intimidating arena for folks. Try and convince your judge to give you 15 or 20 minutes. Some things that I've tried, some judges will actually put you on a clock for the whole trial, which I don't love. But Judge, if you're going to give me 24 or 30 hours, let me have an hour to do voir dire my way, and I'll do the rest of the case in 29. So bargain,
right? Because
that it doesn't matter how well you do the 29 or 30 hours if the jury's not open. You're wasting a week. It's crazy, but the judges that have not read the psychology don't appreciate it, and it's our job to try and argue it and try and get as much as you can get.
Thank you, Mike. Again, Premises Liability, A Guide to Success. It's on Trial Guides. The first one, we're looking forward to book number 2. And it's Michael Neff out of Georgia. Thanks, Michael.
All right. Thanks a lot, Saul.
One of the things we do as we end these podcasts are 2 things. One is a kind of a nursing home tip for my clients that handle nursing home cases. And I did share this tip with you a couple of days ago. Whenever you're handling a nursing home case, I know everybody has this, it really applies to every case. We have this habit of giving it to somebody else to summarize the records, whether it be a legal nurse consultant, a paralegal. One thing I think we all need to get into the habit of before you go to trial, read the chart, read the records. The things you'll find there are astronomical, whether it be false charting, if it's a nursing home or a med-mal case, whether it be admissions, if you're looking just at the ambulance, where the staff said, oh yeah, they fell yesterday. We didn't have them, in their wheelchair correctly. It's incredible. If you want to really take these cases, read the chart and do it yourself. Do you ever use quotes in closing arguments as themes?
No, I have not done that a lot.
So I do. I've always done that. And I have a book of quotes, but I know you're originally from New Jersey. So I wanted to go to my book of Springsteen, which anybody who knows me knows I haven't missed a tour since '78. And that just means we're old, Mike. But yes. It's Counting on a Miracle. I don't know if you remember that song from the Rising album. And this is, I think, is something you can really use in a death case. Sleeping Beauty awakes from her dream with her lover's kiss on her lips. Your kiss was taken from me. Now all I have is this. And I really think that's something we can use in making a story, in saying that, in showing the story of the surviving spouse in a case, that now my lover's, that kiss has been taken from me, and now all I have is this, where they're not complaining, but they're actually trying to be a hero and trying to overcome it. But it's something that makes you think. What do you think about that kind of quote?
Well, you asked me if I use quotes, and I use stories.
Okay.
And Springsteen is a master storyteller. And one thing that he does amazing is talk about yearning and loss and pain and hope and despair. I mean, there's so many themes. And, you know, when you are trying a case and asking for damages, I think the ultimate goal is for you to tap into universal themes. Faith, hope, and love. Those are three big ones. What did this plaintiff lose because of this defendant's choice? And how important is what that loss is? And when you get folks hooked into the themes where they're thinking about their own lives, and that's why song can be so powerful, because Springsteen makes you think about, you know, how important love is to you, or how important that kiss is to you. And jurors start thinking about the value of a lover or wife, a kiss, then you're moving them, you know, and that is when you can ask them for a big number, because now they appreciate what your client has lost.
Michael Neff, thank you very much. It was great seeing you. Great talking to you.
All right. Take care.
Take care.
That concludes another episode of the Jury Thinks What podcast, part of the Lawyer Minds ecosystem. Thank you for listening, and we truly hope it was worth your time. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content that Lawyer Minds has to offer, and engage with us on social media. Your feedback and ideas are always welcomed. See you next time.